Morning, everyone. We have 6 arguments on today's calendar. We'll begin with appeal number 21-3115, the United States versus Albert Rossini. Mr. Butler, good morning.
Good morning. Good morning. Essentially, this is a case that really never should have been filed. One of the first tenets, I guess, in medicine is to do no harm. In this situation, Mr. Rossini was given, I would say, an extraordinary sentence, in that he was facing a guideline sentence of 210 to 262 months, which converts to 17 and a half years to 21.8 years. Judge Lee gave him a departure to 132 months, which basically meant he was given a 10-year reduction in his sentence. Now, Mr. Rossini has had, I believe, approximately 9 lawyers who preceded my involvement in this case. And one of the lawyers, all of his lawyers were extremely competent and extremely professionally experienced. Who preceded me on this case was Professor Richard Klein. Mr. Rossini didn't listen to any of his prior lawyers. He hasn't listened to me. And I believe that, in fact, if this sentence is disturbed, Mr. Rossini is going to essentially be worse off than he presently is now. Because given the fact that he testified at sentencing against my advice, and Judge Lee did, in fact, find him not to be credible, he also has scheduled on July 21st, I believe, of this year, a couple of months before Judge Stark, a trial pending that would impact some of the issues involving this case.
Yeah,
Mr. Go ahead.
Let me just suggest that just do the best you can to advocate for him. He's still entitled under the Sixth Amendment to the effective assistance of counsel in the appeal. You've been dealt the hand you've been dealt, but just make the best arguments you can. You don't have to apologize for anything or try to walk anything back, but go right ahead.
Okay. My essential argument is that although Judge Lee did give him a 10-year reduction, I believe given the extraordinary circumstances that Mr. Rossini does have, in fact, his age...
Mr. Butler, if I could jump in there, please. You're asking us to find a substantially below the guideline sentence substantively unreasonable. This court has never found a below guideline sentence substantively unreasonable. What is it about this case that should make us reach that conclusion for the first time ever, especially given how far below the low end of the guidelines Judge Lee sentenced him?
Well, one of the things that I believe that's unique in this situation is a combination of factors affecting Mr. Rossini. Number one, his wife has breast cancer. Number two, his age. He has a number of medical conditions. He has heart conditions. He has some diabetes. His wife has diabetes. At the time, he was caring for a 93-year-old mother.
All of these arguments that you're making go to history and characteristics under 3553A, and Judge Lee thoroughly considered those arguments, and I believe, based on the transcript, that's why he went so far below the guidelines. So substantively unreasonable is something different than just saying, based on these 3553A factors, you should have given me a different sentence.
Well, I believe based on the totality of those circumstances, the fact that he did depart and that he did depart significantly, that does not foreclose, I believe, making that argument to say that based on the totality of what Mr. Rossini presented to the district court at that time, and given his extraordinary circumstances, that the district court should have gone even further. And the fact that this court hasn't considered that before, I believe each
Well, we've considered it. We've just never found something substantively unreasonable, especially a below guideline sentence.
Well, given the fact that his circumstances were so unique, I believe it warranted a further departure, which I believe under the circumstances, if it was not considered, it would be substantially unreasonable. Because, number one, Mr. Rossini's 74 years old. He'll be 75 in September.
How do you respond to the district court's addressing that issue by saying didn't stop him from going out and committing the fraud when he was that old?
That's true, but subsequent to the commission of that fraud, his 93-year-old mother died. He's had a different outview on life. He's now facing his mortality, and the fact that he was incarcerated during an unprecedented time of a pandemic with all of his medical infirmities. So to say that the court's never done that before, I don't believe the court has ever been presented with these kind of circumstances, coupled with the fact that you have someone who is dealing with a pandemic situation. He's confined, he has family issues, and his health issues prevent him from in any way being a threat to society again. He's basically now a burden to his son, who, if you want to look at some redeeming factors that he has a son who graduated from law school. Mr. Rossini at one point during his life went to Georgetown University Law School for a year. So he can be a productive member of society, given the fact, notwithstanding all of the things that he's done, there's still a hope that he does have redeeming qualities and he can, to some degree, turn whatever the remaining part of his life is around. But he can't do that from a prison cell. And he can't do that with an 11-year sentence, although it was a significant reduction. That's basically a life sentence, given his health considerations. So for that reason, I would say to the court, even though the court has not done that before, the totality of these circumstances do not preclude the court from doing it in this instance. Because based on all of those factors involving Mr. Rossini, I believe he was entitled to it and he warrants additional consideration. Unless there are any other questions, I'll stand on my brief.
Okay, very well. Thank you, Mr. Butler. You have a couple minutes. If the government says something that you want to respond to, you're welcome to.
Thank you.
Okay, very well. Ms. Chung, good morning.
Good morning, Your Honors, and may it please the court. Ashley Chung on behalf of the United States. Here, the district court committed no error in imposing a below-guideline sentence on Mr. Rossini. As this panel referenced, the district court considered every argument that defendant raises on his appeal, and as defendant's counsel acknowledged today, ultimately, most of the issues that are raised on appeal boil down to a grievance with the district court's credibility finding as to defendant, which is entitled to special deference here, and was entirely supported by the record in this case. Furthermore, the defendant's below-guideline sentence was substantively reasonable. The defendant has not come close to rebutting what is a near irrebuttable presumption here that the below-guideline sentence is reasonable. The district court meaningfully and thoroughly considered all of the 3553A factors in arriving at the 132-month sentence. And as this panel also referenced, the district court explicitly noted the defendant's advanced age and health conditions, as well as the potential severity of the sentence it was imposing.
Ms. Chung, can I ask you a factual question just to confirm what I think happened? You'll know.
Yes, Your Honor.
One of the points that Mr. Rossini makes in his brief on page 16 is that the loss amount was determined through an averaging calculation. But that does not seem to align to me with what's actually in the record. And the way I read the record, tell me if I'm wrong, is that at trial the government introduced an exhibit, Exhibit G. And Exhibit G listed the loss amount by investor. So the investors were named, and then there was a corresponding loss amount. And it was the total of the loss amounts listed on Exhibit G that were then reproduced in the PSR that then served as the basis for the loss computation for purposes of the offense level under 2B1.1.
That's entirely correct, Your Honor. There was no averaging in this case, and those loss amounts were loss
So
amounts.
these are
that were-
actual losses for actual victims.
Yes, Your Honor, which were determined and supported at trial through testimony from the victims themselves, as well as through summary evidence presented by summary witnesses as to bank records and various financial
And that's how we get to the
analyses.
5.3 million.
Yes, Your Honor, that's correct. And so briefly, here, there was no error committed by the district court, certainly no clear error in its credibility determination or its factual findings, nor any issue with respect to the substantive reasonableness of the sentence. Unless the panel has any further questions, I respectfully request that this court affirm defendant's sentence.
Okay, very well. Thank you, Ms. Chun. Mr. Butler, anything you want to respond to?
No, Your Honor.
Okay, thank you very much. Mr. Butler, I see here that you took this case on appointment from the court, correct?
Correct.
We very much appreciate your service to the court, to the client as well. We'll take the appeal under advisement, thanks to the government too. We'll move to our second argument of the morning, appeal number 222757, Bo Marvin versus David Holcomb. Mr. Barnes, whenever you're ready. Good morning.
Yes, Your Honor. Robert Barnes, on behalf of the appellant and the plaintiff, Your Honor. May it please the court. This case concerns a 21-year-old boy who answered the door at his father's farmhouse. 3 officers were outside. As the officers knew, he was constitutionally entitled, as this court made clear in Berkowitz, to not answer the door, to shut the door, to be not cooperative, to not answer questions, to be sarcastic, to be any of those things. He at no time threatened the officers or anything like that. They admitted that. He didn't say anything threatening, didn't commit any felony in front of them or anything else. At one point, 2 of the officers say they just got the idea simultaneously in their head to grab him, throw him out of the house, in which case another officer tackles him, tases him, stuns him, and then they got on top of him and start beating him with their closed fist, according to their own testimony. According to the court below, that's completely reasonable. Indeed, the court below determined that if an arrest is completely lawless, that is completely reasonable and has nothing to do with an excessive force test.
Mr. Barnes,
I don't know about that. I don't see any language in the district court opinion suggesting that lawless arrests are okay. What do you have in mind?
Yes, Your Honor. What happened is he interpreted, this court in Bukovic said that the fact that an arrest may be lawful doesn't make it reasonable if the force is excessive. The district court interpreted that to mean that even if an arrest is lawless, the arrest is still reasonable if the force was not excessive. He flipped it on its head. But what this court actually said at 621 F3rd.
why does that matter here, though? Because you're not challenging the lawfulness of the arrest. You've made an excessive force, an unlawful entry and an excessive force. So even if you're right that the district court misspoke about the lawfulness of the arrest, that's not the claim before the court.
Oh, we believe it is, Your Honor. In fact, the court claim was that any use of force is...
But you're not challenging. This is not a false arrest. There was no claim for false arrest or not having probable cause to arrest him. The focus was the excessive force used and the unlawful entry into the home. So why would that matter, even if you're correct, even if your premise is correct?
Yes, Your Honor, because any use of force is excessive if it's not a lawful arrest. So, for example...
Even if it's a lawful arrest, you can't use excessive force. I mean, there was nothing that I saw in the record where you tied anything to the arrest itself.
Yes, Your Honor. The allegation is that any use of force is excessive if the arrest isn't lawful. And that is exactly what this court said in a case cited by the district court, the one the district court got confused on. And this is Carlson versus Bukovic, 621 F. 3rd, 610, 622, Note 19, 7th Circuit, 2010, that a unlawful arrest, a seizure without probable cause, is itself unreasonable. The court earlier in its summary judgment decision says exactly the opposite. Says it's not per se unreasonable to use force in a law without probable cause. What he got confused was the fact that an arrest is lawful doesn't make it reasonable if the force is excessive, but all use of force is excessive if the arrest isn't lawful. And this relates to Indiana law and the state tort claims brought of battery and excessive force. Because Indiana statutes, to cite for the record, Indiana Code 35-4133B, and relevant here, 35-413-2I, say that a force is only justified against a claim of excessive force by a police officer if it's pursuant to a lawful arrest.
Mr. Barnes, I'm confused here. You gotta step back a little bit, okay?
Yes, Your Honor.
I thought that the claim that was made, I think very close to what Judge St. Eve is saying, is that there was unlawful entry into this home. Am I even right about that?
Absolutely, you're right about that.
Okay. Now, if the entry into the home was unlawful, the entry into the home is what was done by the police officers to effect the arrest. Is that correct?
Yes, Your Honor.
Okay. And in the course of effecting the arrest is when the force was used.
Yes, Your Honor.
Is that right?
Yes, Your Honor.
Okay. And there's a separate claim that the amount of force that was used to effect the arrest, the tasing, the punching, what you recounted a few minutes ago, that was excessive under Fourth Amendment standards. Is that correct?
Yes, Your Honor. The only is that there's two different excessive force claims as I read.
Okay, go ahead. What are they?
So the first one is that any use of force was excessive in executing any arrest from inside the home when no exigent circumstances were present. So that's excessive force by itself. Any use of force to execute an unlawful arrest is excessive.
So basically, your argument is if someone is arrested unlawfully, they have a per se excessive force claim. Period.
Precisely. That's
they
precisely.
Get to recover damages.
Yes, Your Honor.
Okay.
But your unlawfulness of the arrest is not based on a probable cause argument. It's based on stepping into the home.
That's correct, Your Honor.
So you agree there was probable cause to arrest here?
I don't concede that there was, on the factual record here, there was probable cause to arrest. But it doesn't...
You don't seem to be disputing that in your briefing.
The dispute is focused on the unlawful. It doesn't matter if there was probable cause or not.
I think Judge St. Eve, I think, is right. What she's saying is that you're arguing that there's a Fourth Amendment infringement at the threshold of the home, at the door.
Yes, Your Honor.
Okay. But you're not arguing that they lacked probable cause, and the reason that I didn't see that argument in your brief makes good sense to me. There was a 911 call that he threw a chair at his mother, hit her in the head, and cut her mouth open.
And she was bleeding when the police officers
So of course
arrived, and
there's...
she told the police officers that.
So that's why you didn't argue that, or at least that. I mean, I'm willing to give you all the credit for that. You can't make that argument.
Well, I would disagree there because two things. One, the call was not about a request for battery. It was a wellness check call.
But
Well,
does that...
hold on. I mean, when they show up, they see the mother outside, right? She's bleeding from the mouth.
And she said she's fine. She doesn't want him arrested. That she just wants a wellness check.
Well, they're not, I mean, are they constitutionally compelled to listen to her?
No,
And
but
she
they were
says
constitutionally
we're
compelled
worried he's
to.
going to take his life. He has a box cutter, or he carries a box cutter with him. I mean, this is an extremely delicate position the officers find themselves in.
And she told them he threw a chair at her, which is what busted her lip open.
And that's why they decided to violate the law, and the lower court let him get away with it. And the only question is whether this court lets him get away with it. Because let's
Don't you
take
think
what Your Honor is saying is
That
correct.
statement's a little bit dramatic,
Yeah.
Is
Mr.
it?
Barnes.
Is it?
It's because if they had probable cause to believe that a battery had committed, which is exactly what they had here, based on what his mom said, then they certainly have a right to arrest him.
But not to yank him out of the house.
But he had a jury trial on that issue.
Only some of the issues went to jury. Two different things. Only one part of the issue went to jury trial. What you're saying is they go there. They know they want to arrest him, according to the court's understanding. They know they legally can't arrest him as long as he's inside the house. So they yank him out. They lie about it in their depositions. They initially say, oh, he was outside the house when we arrested him. Photographs prove him wrong. And then what the court says is no use of force in that capacity was excessive force. Not even the force used to remove him from the house or the subsequent force.
Let me ask you this question. Did the Fourth Amendment, in your view, compel them, after talking to the mother, to return to their cars and drive back to the police station?
No, it just compelled them to not remove him from his home without exigent circumstances.
But that went to the jury, as Judge Kirsch just pointed out.
No, it didn't.
The unlawful entry, yes, it did.
Only part of the unlawful entry went to the jury, and then the jury wasn't given the Berkowitz instruction on a plain statement of law that was the whole essence of the case and the essence of the defense.
Let's talk about that jury instruction. In your reply, you essentially say that it's not essentially, you do say it's not necessarily inaccurate, which is a little bit different from what you argued in your original brief. What about instruction number 9 are you claiming was the error?
The failure to instruct the jury that you are entitled and you have an expectation of privacy even when you open the door in response to a police officer knocking on the door.
So the Berkowitz question. Now,
exactly.
The court gave the same jury instruction 9 in its preliminary instructions, and there was no objection. Why haven't you waived or forfeited this objection?
I don't see that as waiver under these circumstances.
How? Because there was a jury instruction conference. The court proposed, I'll refer to it as jury instruction 9 for simplicity purposes, for preliminary instructions. You didn't object. The court gave that instruction, and now at the end of the case, you want to change that instruction.
The court, the trial counsel objected prior to it going to the jury.
But not at the preliminary stage. So what's the court supposed to do? Say, oops, I was wrong in what I instructed you before trial? Let me give you a different instruction?
It is commonplace for clarifications to be issued at the end of the case once the facts of the actual trial are
It is not commonplace to change an instruction on the law from what you gave them in advance of the trial.
I don't see it as a change. I see it as an addition. In other words, it's just making clear that the jury knows that you do, in fact, have a reasonable expectation of privacy, even though you open the door.
So why would that, even if you're right, and the court should have given a Berkowitz instruction, why would it matter here when the whole theory was based on exigent circumstances, not based on whether or not stepping over the doorway, there was a reasonable expectation of privacy?
The jury could reasonably conclude, because of the absence of a Berkowitz instruction, that him opening the door waived his expectation of privacy.
But if there are exigent circumstances, the expectation of privacy doesn't matter.
There were no. What were the exigent circumstances?
Well, that's what they argued to the jury. That's my point. I don't know why their theory, and I read the closing argument, was all based on the exigent circumstances here. That's an exception under the Fourth Amendment. So I don't understand why even if the reasonable expectation of privacy instruction should have looked different, why that matters here when the theory was exigent circumstances.
Because we don't know what the jury determined. We don't know if part of what they determined wasn't that there was no exigent circumstances, for which the evidence was very weak, but was instead, they concluded that he opened the door, so he had no expectation of privacy. That was the key to the Berkowitz instruction. And that's useful for future cases moving forward, independent of this case, is for courts to have clarity on that aspect. The last aspect, before I'll reserve the remainder of my time, the court also got confused on when personal involvement is required. The court concluded personal involvement effectively required direct participation unless they were a supervisor. But that is not what this court has established. This court has established in a range of cases going all the way back to Crowder in 1982 that if you turn a blind eye, if you acquiesce, if you know about it, if you consent to it, if you join in on it, that direct participation is not required under Gossmeier. All that's required is direct involvement at some level. Here you had 2 officers pull him out, a 3rd officer immediately tackle him, and another officer then get involved in stunning him and beating him. These are joint involved participants. So at a minimum, the court should clarify that it's not a case that you have to directly throw the punch or be the supervisor of the person throwing the punch. If you're physically present and you do engage in conduct that can be interpreted by a jury to be acquiescing in it, then that constitutes personal involvement under this court's precedents dating back to 1982.
That sounds like a failure to intervene claim.
That's how the courts have defined it. It's kind of like aiding and abetting. It's a various form of joint participation. So it doesn't require a separate allegation historically. Personal involvement is just, you're there, you know about it, you consent, you acquiesce, you turn a blind eye. Something that shows beyond, oh, that one officer was down the street 10 blocks and you want to blame him for something some officer did. That's the scenario here, and that also warrants clarification. I'll reserve the rest of my time. Thank you.
Yeah, very well. Mr. Agostino, good morning.
Good morning, Your Honors. May it please the court. I think the starting point for this case is to look at what the complaint is. There was 3 legal theories that were the plaintiff was pursuing this case on. The first was the warrantless entry. The second was the excessive force. And then the third was a tag-along claim under state law for the excessive force under state law claim. So there was no allegation of failure to intervene. And so looking at the theories that were in fact asserted in the complaint and how the court processed those claims on summary judgment, I think the court correctly ruled that the plaintiff did not come forward with sufficient evidence on the excessive force because there was resistance in the arrest attempt. The force was the minimum amount necessary to be used under those circumstances to get control over the claimant in that. And it's not enough that the claimant in this case rely on what they alleged in the complaint. At summary judgment, they were required to come forward either with affidavits, deposition testimony, something under oath, some form of admissible evidence to show that there was a genuine issue of fact. They did not do that. In fact, even on appeal, it seems that the appellant is relying on allegations to try and say there was a fact issue on the force used, rather than point to specific deposition testimony or some form of affidavit. So there was nothing to show that there was a genuine issue of material fact with respect to use of excessive force. Then when you move from there to the entry, the court said that there's a question of fact here. Was he in the house or out of the house? And did not really deal with the exigent circumstances in the summary judgment process. But that did go to trial.
Was your theory at trial exigent circumstances?
Yes, it was.
That's what it seemed to be.
Yes, it was. And the exigent circumstances, I think, were very clear, starting with the 911 call, getting to the scene, finding that the mother had, in fact, been injured by her own son. She's bleeding. She didn't want to cooperate initially, then finally did give the facts. They get to the house. They're made aware that he's got a box cutter. He's in the house. His dad is in the house as well. So they've got a young person here, a young man who's already injured his own mom with a box cutter, who may be suicidal, who may be thinking that maybe he's going to injure his dad. Look at the officers were looking at what they did and was it reasonable from their perspective at the time that they did it, not from hindsight. So looking at what the officers are dealing with when they get to the house, now they've got someone that's injured his mom in the house with another person in there. That is exigent circumstance.
So is the way you presented that argument at trial that even if there was a crossing of the threshold of the door, that occurred in the exigencies of these circumstances that the officers faced, and therefore there's no Fourth Amendment violation?
That's correct, Your Honor.
It does seem, in looking back at the district, it does seem, precisely where people were situated and where he was within the doorway area. The quite disputed. They may well have reached in, and that's why you advanced it in terms of exigency.
I think that was the better argument. There was confusion and dispute in the evidence of exactly where he was. Was his arm outside, past the threshold and outside? That seemed to be hyper-technical, and when compared to having an argument that's based on the facts that supported exigent circumstances, that was the stronger argument.
And they reached through, grabbed him, and then the tussle began, but that was after the box cutter came out of the back pocket.
That's right. The box cutter coming out of the back pocket provided a distraction for the plaintiff. He was distracted, and that was at the moment that the two officers made a split-second decision to take control of the situation, which was the right thing to do. I think on the jury instructions, I think the court, as already been pointed out, did have a discussion about whether this was waived, but the court also gave 3 other instructions that very clearly told the jury. Instruction number 2, that was the issue instruction, said that the issue is about unreasonable entry into the home. Number 6 clearly told the jury that entry into the home without a warrant is presumed unreasonable unless you have consent or exigent circumstances. And number 8 addressed what exigent circumstances are. But the jury was well instructed that going into the house without a warrant is presumed to be unreasonable. And then the jury was told you have to look at the exigent circumstances as a justification for that. And that's what happened.
And the substance of instruction number 9 seems to align with our prior decision in sparing, correct?
I'm not at this moment particularly familiar with that case. But,
yeah, I mean, I think there's a question of whether sparing is fully aligned with where the Supreme Court is at on the Fourth Amendment, but I think the instruction aligns with where our court is at.
It is, and it also tracks very much, I think, with where the pattern jury instructions are too. So, which I think may be derived from that. So I think under the at trial is not a misstatement of the law. It didn't cause confusion, and when you look at what the theory of the case was and as it was presented to the jury and what was emphasized, there was more than enough evidence presented to support the exigent circumstances exception to the Fourth Amendment claim. And so at the end of the day, the claimant got their day in court on the issue where there was a fact issue. The jury did not believe the claim, sided with the defense. And for those reasons, I think, unless there's other questions, I believe the trial court should be affirmed. Thank you.
Okay, very well. Thank you. Mr. Barnes.
Yes, Your Honor.
Yeah, go ahead. You can take a minute. We'll round it up.
On the question of evidence for the excessive force claim, the summary judgment motion filed that was cited in the appendix is all to to Bo Marvin's actual deposition testimony. And
I'm sorry, could you repeat that?
The opposition was based on Bo Marvin's deposition testimony, so it wasn't just based on the pleadings. And what was detailed, even the police officers acknowledged that when they started to execute the arrest, they didn't tell him he was under arrest. They hadn't asked him any questions concerning his arrest. The only potential weapon on him, the bow cutter knife, had been removed from him and was in his father's possession. And they admit he never threatened them. The only crime they allege is is a misdemeanor battery, which was ultimately dismissed later on. No charges were ultimately brought to trial in the case. And in that circumstance, how is what he did, how does that justify a court finding as a matter of law that the force used was reasonable? Because you're talking about being tased, being stunned, being tackled, being beaten with closed fists. These were facts that, as this court warned back in 2005, Abdullahi versus City of Madison, 423 F. 3rd, 763 at 773, 2005, summary judgment should, quote, be sparingly used in excessive force cases, because there's always going to be factual disputes. But here, even the facts not in dispute give substantial reason for this to have reached a jury on those questions. Thank you, Your Honor.
Okay, thanks to you, Mr. Barnes, Mr. Agostino. We'll take the appeal under advisement. Okay, our third argument of the morning is in appeal number 223009, St. Vincent Medical or Ascension Health versus the U.S. Department of Justice. Mr. McNeil, good morning.
Good morning, Your Honors. May it please the court. This is an appeal arising out of a 2E case, and if the Department of Justice can refuse to participate in the state court discovery proceedings in this case, then the Department of Justice will be able to refuse to participate in state court discovery in any case. The 2E request was...
Mr. McNeil,
yes, sir.
what is the best case scenario, the testimony that you're going to get from the Assistant U.S. Attorney and from the DEA agent? What are they going to say?
They're going to say that when they approached Dr. Story with the investigative subpoena, after he referred them to their counsel, to his counsel, Mr. Blackington told Dr. Story's counsel that he was not currently a target of the investigation, but could potentially...
Hold on for a second. I'm confused. You said when he approached Dr. Story, he told Dr. Story's counsel. So the Assistant U.S. Attorney never spoke with Dr. Story, right?
Not until right before the grand jury testimony, 6 months after the termination of Dr. Story's employment.
But he never. So there's best case scenario. There's no evidence, none, zero, that the Assistant U.S. Attorney ever told Dr. Story he was a subject or target of the investigation, right?
That is true.
But you have this letter from the Assistant U.S. Attorney that says you are a subject of the investigation. I don't even understand why we're here.
Sure.
I mean, I understand what you want, okay? But a lot of parties want this. And the Department of Justice says, no, you can't have it for a lot of valid, good reasons, including Rule 6E, including the effect on the law enforcement investigation. But it sounds like you already have it.
Well, here's the issue, though. This case is set to go to a jury trial in December of this year.
And you're going to cross-examine Dr. Story with this letter, and I don't know how he is possibly going to get out from under it. But the best case scenario is you can maybe cross-examine him with the Assistant U.S. Attorney told your lawyer, objection, hearsay, sustained.
Not exactly.
Okay.
So
tell me where I'm wrong.
What will happen is Dr. Story will say, I was not aware. I never spoke to Mr. Blackington. So how can he say what I am aware of? What Mr. Blackington will say is, I spoke with Dr. Story's counsel, and this is what I told him.
But isn't Dr. Story's counsel going to testify to that?
Potentially, if the court lets her testify. Because
Well, you have the deposition testimony from her where she says that.
She says that. But
She says that she was told that her client was a potential subject, and she conveyed that to Dr. Story.
She testified that he was could become a target of the investigation.
Why isn't that sufficient?
Because counsel on the other side of the case has objections too, and they say that's hearsay for Ascension personnel.
Why do you need that for the truth of the matter? Why isn't the relevance here just what he was told? That he was informed that he was a potential target.
This goes to the provision in his employment agreement with Ascension.
I understand why you want this, but I don't understand why his state of mind or what he was told wouldn't be relevant, which gets you around hearsay.
Well, it does to a degree, but if we want to use the evidence for as many evidentiary purposes as we can, including the truth of the matter asserted, without some limiting instruction attached to it to the jury that says you can. But
that's not the standard that we look at here. If we're looking at whether or not there's a need for this, whether it's necessary, you have to pick up on what Judge Kirsch said. You have the proffer letter where he's told you're a subject, and he signs it.
Right.
So that sounds like an admission to me.
Well,
you have testimony from his lawyer that she was informed that he was a potential target, and she conveyed that to him. And you have testimony from your own client's lawyers that they were told that he was a potential target or a subject of the investigation. So when you look at what you need, I share what Judge Kirsch has said. I don't know why you need this.
The provision in Dr. Story's employment agreement comes down where it imposes upon him an obligation to disclose to his employer information with legal ramifications, comes down to his reasonable belief of whether there were legal implications in with respect to the matter that arose. Here, the department, Dr. Story has testified that the only thing he understood this investigation was about was one of his patients and patients associated with that patient. That it was never about his prescribing practices, his record keeping, or his.
And you have the proffer letter to impeach him.
The proffer letter seems absolutely devastating. I mean, he right above his signature, he says, "I understand the terms and conditions set out above, and I agree to proffer under those terms and conditions." So one of those terms and conditions is the first sentence of the proffer letter. I mean, if we're thinking about it, I know you're in an Indiana court for your trial, but under the federal rules of evidence, it wouldn't even be hearsay. It seems to me it's an admission of a party opponent.
Well, I don't disagree with you there, Your Honor, except he will testify that he had, even though he signed that letter, he had no knowledge that that was in fact the case.
Well,
and that letter comes
okay,
6
but
months.
you're gonna say you signed a letter, okay, and now your testimony is the letter doesn't mean what it says?
Well, I will say this too, Your Honor. That letter did not surface in the litigation until March of 2022, after we had
Are you
already.
precluded from using it in the state court litigation?
We're not precluded from using it. No. The other side has moved to exclude it. There's an in limine ruling that says.
Yeah, I mean, we're not going to issue evidentiary rulings for the upcoming trial, but I'll just make the observation that that letter seems awfully strong for you.
And I don't disagree with you, Your Honor. One other issue with respect to that letter is it's dated February 21st of 2021, which is 6 months after the termination of Dr. Story's employment. This all arose in the summer and early fall of 2020, when Ascension's first involvement was when it was contacted by the Department of Justice to say, "Who is Dr. Story? We just received records with your name on it, with your name all over them, from him in response to a DEA investigative subpoena." That's what caused Ascension to begin its own internal investigation. And it was during that investigation, there were more than one conversation with Mr. Blackington and Mr. Radcliffe about what they were looking at. And the testimony from Ascension personnel is they were told by Mr. Blackington and Mr. Radcliffe that they were looking into Dr. Story's prescribing practices. Dr. Story denies that, and Dr. Story's counsel contends.
Hence, that's why the proffer letter says what it says.
Well,
you are a subject of a Title 21 investigation.
Sure. We also have the issue there of what is a subject versus what is a target. So as the DOJ manual defines a subject to be someone of interest to the investigation, whereas the target is the person who is under investigation. So
I assume his lawyer will testify she explained that to him.
That gets into sort of this attorney-client privilege issue of
that he's put at issue here.
I don't disagree with you, Your Honor. That's subject to state court evidentiary rulings as well.
I thought the state court already addressed that, which is why you were allowed to depose her in the first place. I thought the state court had already addressed that he had waived the attorney-client privilege given his defense here.
There's two different lawyers that we're talking about. One was Kathleen Mitsoukas, who was his criminal counsel in the summer of 2020. The other is Kathleen Delaney, who's his trial counsel currently in the state court case. The deposition occurred with respect to his criminal counsel, Ms. Mitsoukas. There was a hearing at some point in the case where there was allegations. There was testimony given that the judge determined to open the door to other privileged communications. We were not able to depose trial counsel for obvious reasons. In the deposition of Ms. Mitsoukas, she relayed what she was told by the Department of Justice, by Assistant U.S. Attorney Blackington. We have their email correspondence. But the issue comes back to Ascension's ability to present the evidence it needs to present at the trial, and the Department of Justice has said you can't depose our personnel because of these grand jury secrecy concerns and this law enforcement investigative privilege. We think those are misplaced in this context because of the narrow scope of the information we want to get from them. They are percipient witnesses. This is not a situation where we are asking anyone what occurred before the grand jury. We are not asking them for the results of their investigative memoranda concerning their investigation. All we want is to ask them, did you tell Dr. Story this? Did you tell Dr. Story's counsel the following? Did you say to Ascension personnel that you wanted to interview Dr. Story's coworkers about Dr. Story's prescribing practices? Those are not subjects that in any way reflect what occurred before the grand jury. That's the U.S. versus Stanford case that this court has decided, where it talks about the value of the evidence for the value of the evidence itself intrinsically. It's not something that reveals what occurred before the grand jury. It's the substance of the testimony itself. That is the evidence. They were parties to a conversation that, but for their identity of their employer, would have been deposed already. The grand jury rule doesn't interfere, should not interfere with the ability to depose them on these topics.
Well, they obviously have a different view of that.
Yes,
and the
they
question
do.
is whether the view that they've taken is arbitrary and capricious.
Correct. And I think the view they've taken is just wrong as a matter of law, because their TUI regulations require them to consider two things. One is the procedural context and rules from which the case arises. The other is the substantive law of privilege. The department has taken a position substantively that this testimony that Ascension wants is protected from disclosure by the grand jury secrecy rule and the law enforcement investigatory privilege. Those are substantive legal determinations that are wrong as a matter of law. They are per se unreasonable, and therefore they're arbitrary and capricious. We talk in the brief about the standard of review and the appropriateness of the discovery rules. I think 16 CFR 26A, that standard where it incorporates the underlying discovery rules, is what brings the proportionality considerations into the question, that brings the scope of discovery concerns into the question.
Has any court ever found, any circuit court ever found, that you look at the Rule 45 of the Civil Rules of Procedures standard, or Rule 26, any of the civil rules, when making a determination about whether the department's reasoning was arbitrary and capricious when the underlying litigation started in state court as opposed to federal?
Not that I'm aware of, Your Honor. Candidly, not that I'm aware of. One final thing before I reserve my time is a question of remedy. Normally in an APA case, it's a remand to the agency for further consideration. For the reasons I alluded to, Judge Scooter, that would be inappropriate in this case. The trial's in December of this year. They've already made their determination legally. So really we're into a legal, were they correct legally or not? And because they are incorrect on the substantive law of privilege, there's no basis to remand it to the agency for further consideration. Their personnel should be remanded to the district court to order their personnel.
Yeah, that's what you want us to hold.
Yes.
Right, I understand. Yeah.
Thank
Okay,
you.
very well. Mr. Schultz?
Thank you, Your Honor. May it please the court, Benjamin Schultz on behalf of the Department of Justice. The plaintiff in this case is asking for something that is really unprecedented, and that's a court order a federal court order in connection with a state court case asking the Department of Justice to give testimony over its objection about a federal criminal investigation. The government in this case considered Ascension's request. It concluded that the law enforcement investigatory privilege, grand jury secrecy rules, and the policies underlying those rules, in addition to the formal rules and privileges themselves, as well as the fact that the information that Ascension was seeking was either not really relevant to the reason identified in the TUI request or otherwise cumulative with evidence that Ascension already had. All of those factors showed why it was not, in the Department of Justice's reasonable judgment, appropriate for the government to make its prosecutor and DEA agent available. I'd be happy to address any questions the court has about any of the specifics, but I think the court's colloquy has just revealed and underscored why it was at the very least reasonable for the Department of Justice to conclude that this evidence wasn't really going to do anything for Ascension beyond what it already had, certainly with regard to the very specific reason that Ascension identified in its 2A request, and that in any event, grand jury secrecy or the law enforcement investigatory privilege or the policies underlying all of that were all reasons why the government was going to resist that request. Again, if there are specific questions, I'm happy to address them.
Okay, hearing none. Mr. Schultz, thank you very much. Mr. McNeil?
One comment.
Yeah, go right ahead.
Thank you. Thank you. The council just said it too, and the Department of Justice said this in their initial response to our 2E request, and they said it in their brief. They have a different conception of the relevance scope than Ascension does. The department has framed it as the only relevance that we're seeking is what Dr. Story knew about his role in the investigation, and that's just not accurate. What the relevance statement was, here are the conversations that occurred, here are the constituents with whom those conversations took place. We want to depose your personnel about those conversations. So I think that's clear, but because council said it again, I just want to make sure that we had the chance to say the relevance scope is the conversations with Dr. Story, his counsel, and Ascension personnel about what they talked about. That's all. Thank you.
Okay, you're quite welcome. We'll take the case under advisement with thanks to both counsel. Move to our fourth argument of this morning, the United States versus Christopher Simmons. It's appeal number 221321. Yeah, Mr. Piakowski, good morning. Yeah, whenever you're ready.
May it please the court. We certainly recognize that a challenge of the sufficiency of the evidence presents an incredibly high bar. But we think in this instance, this case poses some fairly interesting questions that make this case somewhat atypical in terms of a challenge of the sufficiency. In Flores Figueroa v. United States, the Supreme Court analyzed the statute prohibiting aggravated identity theft, and it drew a clear line between a means of identification that is merely counterfeit on the one hand, and a means of identification that the offender knows belonged to another person. Part of the reason that the court drew this clear line was that it didn't want to turn this law into a lottery, where offenders who happen to guess right are guilty under 18 U.S.C. 1028A, and those who don't aren't. And that, in our opinion, is the biggest problem with the government's case here. The problem is that if we affirm the judgment here on this evidence that doesn't look like the evidence in any other case addressing a similar question, we leave open the possibility that Mr. Simmons happened to guess right and is nevertheless guilty under the statute. In other words, affirming the judgment here would blur the line that the Supreme Court drew in Flores Figueroa. The specific question before the court today is whether the government presented enough circumstantial evidence for the jury to infer that Mr. Simmons knew the number he used belonged to a real person. The Seventh Circuit hasn't really articulated a broadly applicable standard on that question. It's sort of nibbled at the edges, but other circuits have. And as we note in our brief, the popular test involves repeated and successful testing of the means of identification prior to the charged conduct. It originated in the 11th Circuit, the 9th and 6th Circuits that both appear to have followed suit. Other courts have found that when the government presents evidence providing a little bit of color on how the offender obtained the means of identification, I should say, that can be sufficient to create the permissible inference for the jury. In cases where the offender uses other items or information in conjunction with, in this case, the Social Security number, that are also tied to the victim, that creates a permissible inference.
Mr. Piakowski, let me tell you what's run through my mind, and you can tell me I'm mistaken or point me in another direction.
Yes, sir.
When I look at the email exchange on the 23rd, you know it well.
Yes.
The one in Government Exhibit 118. It looks to me like your client, he succeeded in that initial credit card, with the $15,000 credit card application. And then things go south for him when he gets greedy and he asks for the auto loan right on the heels of the success with the credit card application. And then the fraud flag goes off and it's unwound and they tell him you got to come in and open a savings account, and et cetera, et cetera. My question is this: why couldn't a jury, when they're gathered and deliberating, say that he had to have known when he was approved for that credit card before he oversteps and asks for the auto loan right on the heels of that? But he had to have known at that point in time that he either guessed right on the Social Security number or the Social Security number he bought on the street or whatever people are thinking. It's real. Because there's no way he would have been approved. And then he turns around, of course, on the 24th. You see where I'm going with this?
I do.
Okay. So my question is, under the standard of review, which you quite candidly acknowledge, we appreciate that, why couldn't a jury sitting in the room deliberating say, oh, he knew, and the reason he knew is because he got approved for that credit card on the 23rd?
Your Honor, I do not mean to be glib, but
it's
quite simply because a success ain't a success unless it's successful. And ultimately, that same provisional, what the government is now referring to as a provisional approval, ultimately that application was denied within hours on the same day, and Mr. Simmons was informed of that fact on the same day in real time.
Right.
So in other words, he wasn't successful in obtaining credit. He was informed via email that he had been approved, but that there were extra steps that he had to take for them.
Yeah, so I get that argument. I think that's the argument you have to make. And the question that I keep coming back to is the jury compelled to go down that road as opposed to the one I was going down and articulating the question to you, because I thought the only reason he's denied is because he makes the very bad choice. On top of trying to defraud the bank to begin with, but he makes the very bad choice of asking for the auto loan immediately, and that's where the red lights and sirens go off for the bank.
Yeah, we're not here to argue that my client is guilty of good judgment.
No, I know, but it's, I think, I don't know. It just seems to me a jury could say he knew he got approved for that credit card and then he screwed up.
Well, let me try to address your question in terms of the case law.
Yeah, go ahead.
And the problem here is, as I said before, the popular test is repeated and successful testing prior to the charge conduct. So as a threshold matter, this provisional approval that took place, which may or may not be a success within the meaning of 1028A, did not take place prior to the charge conduct. This is all within the conduct that's the subject of the complaint.
Well, hold on. What isn't count the 1028A counts tied back to count 2, is it not?
Correct. But he was also charged with bank fraud in connection with the initial applications, if I'm not mistaken.
Okay. All right, let me just look at count. So count 2, count 2 is what happens the next day.
Correct.
January 24th, right?
Correct.
And that's when he reuses. Your point, of course, is he didn't know when he reused that it belonged to a person because he was unsuccessful on the 23rd.
Not only that, Your Honor, but he was specifically told that they weren't going to rerun his credit no matter how many applications he submitted within a 30-day time frame. So as far as he knew, the lender scrutiny to which he was subjecting this number was only going to take place once, and only on the first application that he submitted to the credit.
And he was
Why is it-
successful.
And why
That's
isn't
it.
that just an issue of fact for the jury?
Right.
Well,
I agree that's a factor you could argue, but that sounds like a jury argument to me, not a sufficiency of the evidence when we're reviewing the record in the light most favorable to the government.
The only answer that I can give you on that count, Your Honor, is that in every other case where the court has faced a similar question, in other words, what is the critical mass of circumstantial evidence that the government has to show that permits the jury to make that inference? And in every other case that addresses that question, the facts, frankly, just look different. There's an added piece of information or an added document that's used in conjunction with the Social Security number. There are verified, successful, and repeated tests, in some cases over a span of several years.
What about the use 10 to 15 times with various lenders before he submitted the Social Security number in connection with the credit card here?
I'm glad you brought that up because, and I've read the record several times now, and I can't tell if the government made any attempt, in fact, as far as I'm concerned, they didn't make any attempt to tie those open inquiries, the number of which is somewhat nebulous, to tie those open inquiries to Mr. Simmons. And the fact that the number did belong to a real person raises the possibility that they weren't all, or some, or most, his doing. The government presented no evidence that indicated that Mr. Simmons was directly tied to those additional inquiries at other financial institutions, and the government made no attempt to show that any of those inquiries were successful. And so I think that fails on both counts.
You want to save your remaining time?
I will.
It's up to you.
No, I will. Thank you.
Okay. All right. Very well. Ms. Boyle, good morning.
Good morning, Your Honors. May it please the Court, Counsel, my name is Catherine Boyle on behalf of the United States. Defense counsel has recognized the high bar for the sufficiency of the evidence issue here, whether any rational juror could have found Mr. Simmons guilty of aggravated identity theft, and here the only issue is whether he knew the Social Security number he used belonged to another individual. Initially, Mr. Simmons' counsel makes the point that this case is not exactly like any other case cited in the briefs. It doesn't have to be. What we're evaluating here is whether there was enough circumstantial evidence for any rational juror to have determined Mr. Simmons knew the Social Security number belonged to another person. Here, there was ample evidence in the record. As Your Honors noted initially, we have the fact that Mr. Simmons knew that the Social Security number had been successfully run in relation to his first MasterCard application, and he was told that in very clear terms by Greg Davis in an email. We also can consider the fact that Mr. Simmons does decide to repeatedly submit the Social Security number, including after that pre-approval, to the bank for potentially additional scrutiny. And it's not clear that Mr. Simmons, I agree that there is a factual issue here, but it's a factual issue for the jury, as to whether Mr. Simmons believed that the Social Security number would be run again. I believe there was an indication in this case, especially once Mr. Simmons' application was flagged for fraud, he might not have known if it would be run again or not. He doesn't know the bank's processes at that point. Additionally, we have the issue of the signature card when he opened the savings account, and that to me suggested that the bank was not running his identification information for a credit card check, and Mr. Simmons was explicitly told that on the Social Security card. It shows that the government, or that the bank and the financial institution, the credit union in this case, was more interested in verifying Mr. Simmons' identity to prevent money laundering, to prevent terrorism, which suggests potentially a different check and another use of that Social Security number where it could be rerun. In addition to this repeated and knowing subjection of the Social Security number to lender scrutiny, it's quite significant in this case that Mr. Simmons continues to do that even after he is flagged for fraud. He is so confident in his Social Security number that he actually agrees to go into the bank and does go into the bank, into the credit union. I keep saying that incorrectly, Your Honors. Goes into the credit union, and while he's at the credit union, he emails Greg Davis and says, hey, should I check in about that sort of potential denial of my credit card application? This is noteworthy confidence in the Social Security number and in the information he's submitting, that he is willing to be at the financial institution and asking questions about the denial of the application. I also think a really interesting point in this case is there is one point in time where Mr. Simmons provides a Social Security number where he does not believe it's going to be run. That is when he goes to cash the check related to the Audi loan that Mr. Canterbury obtained. So Mr. Simmons goes to cash this check. He provides an ID. He gets cash in hand. And at that point, as he's about to leave the bank, they say, oh, could we get your Social Security number? He writes down a number on a scrap piece of paper that doesn't have an appropriate number of digits, and it's not a real Social Security number. That choice to me seems deliberate. It's the only point where we know Mr. Simmons didn't believe that number was, or at least was likely to think that that number was not going to get any additional scrutiny. Additionally, the jury could have looked at the fact, it's pretty coincidental. Mr. Simmons applies for some very expensive car loans and conveniently has a credit score of 796, which is quite high. a jury could infer from that Mr. Simmons had deliberately selected a Social Security number with a high credit rating to make this fraud scheme more successful. Additionally, I think Judge St. Eve mentioned the issue that there were multiple open credit checks from other financial institutions regarding the Social Security number used by Mr. Simmons. That too indicates his confidence. This is a real number that he wants to repeatedly use. He's not just making up a series of Social Security numbers and trying them out to see if they work. And I would also note that in the case law, the case law repeatedly says a reasonable jury can infer that financial institutions are only going to offer savings accounts credit to real people, and Mr. Simmons also used real information throughout his scheme. Your Honor, I'd like to move on briefly to the loss amount issue as well, and here the court is reviewing for a clear error the district court's determination of loss, so we're looking at another high bar. First of all, I'd like to note, defense counsel has cabined this issue to whether the loss amount was above $150,000. So even if we were to take out one of the credit card applications, we would still be above the $150,000 amount, and we would still have the 10-level increase. But here we think that all of those were appropriately included. The district court decided that on the basis of the entire record in the case, Mr. Simmons showed, as Judge Scudder, as you noted, incredible greed. And the court found that the gist of the entire record demonstrated that Mr. Simmons was out to get as much money as possible from the bank. Of course, the court didn't include Mr. Simmons' withdrawn application, but the court did include the amount obtained for the Audi loan, the first MasterCard application, the unspecified auto loan, and the second MasterCard application and the Maserati application. There is no evidence on this record. Defense counsel tries to say that Mr. Simmons was only interested in one of each type of loan, but we've already seen a pattern of criminal conduct based on the Audi loan. We know Mr. Simmons was interested in more than one car loan because they had already achieved the Audi loan. It's also interesting that when Mr. Simmons submits his second credit card application, Mr. Canterbury, his conspirator essentially, the person he's plotting with for these fraud schemes, submits a credit card application about 5 minutes afterwards. These are two individuals who are just trying to get as much money as possible out of the credit union. After their initial success with the Audi loan, they viewed the credit union as an easy mark. And this is a factual determination by the district court, and on the record that we have here, we cannot say that the district court clearly erred. If there are no further questions, the government will rest on the arguments in its brief and request that the court affirm. Thank you, Your Honors.
Okay, very well. Thank you, Ms. Boyle. Yeah, Mr. Piakowski.
Just a couple of quick points. With respect to the government's argument that Mr. Simmons displayed noteworthy confidence when he submitted these applications, the case that the government cites in support of that argument, Doe v. United States, I believe it's an 11th Circuit case, the court in that case specifically cited the fact that the defendant in that case had repeatedly and successfully tested the means of identification, and that was the most significant factor in them determining that there was a sufficient nexus for the jury to infer the requisite knowledge under the statute. And moreover, they said that his noteworthy or unfaltering confidence, is the way they describe it in the case, was stacked on top of this repeated and successful testing. My bottom line here is that illustrates the point that this case, this nucleus of facts in this case, is substantially different from the nucleus of facts in every other case like it in other jurisdictions. Point one. Point two, on the district court's error in terms of calculating Mr. Simmons' intended loss. I would just point out that it was the government's burden to prove and the district court's obligation to find by a preponderance of the evidence that Mr. Simmons was being sentenced only for the loss that he intended. And what is problematic to us here is the fact that during the sentencing hearing, the judge, in adopting the government's argument that Mr. Simmons was out for everything he could get, appeared to point to a lack of evidence on Mr. Simmons' part as opposed to an accumulation of evidence on the part of the government. And I think that's problematic. And if there aren't any other questions about that, then.
Okay, very well. Mr. Piakowski, Ms. Boyle, thank you very much. Mr. Piakowski, you took the case on appointment from the court, right?
I did.
We very much appreciate you doing that. You served your client well, and thanks to your firm, too.
You're welcome.
Okay, thank you. Move to our fifth argument of this morning. Michelle Gies versus the City of Kankakee. It's appeal number 22-2022. Ms. Walters, good morning.
Good morning. May it please the court. My name is Kelly Walters. I am the attorney for former Lieutenant Michelle Giese, plaintiff appellant in this case. Today we are asking the court to reverse the district court's decision to grant the defendant's motion for summary judgment. It's our position that a jury should be the one to determine whether the attack on Ms. Giese on October 18, 2018 was a Fourth Amendment violation. Additionally, the jury should hear the disputed facts regarding whether the city was aware of Lieutenant Boyce's history of violence and the actions to cover it up before deciding on the validity of the Monell claims against the city and against the chief of the fire department. Finally, a jury must hear the actions following the attack by both the city and Ms. Giese to determine whether Ms. Giese has a retaliation claim under Title VII.
Can I ask you a question about that?
Yes.
There's one of the arguments you raise, or one of the issues that you raise with respect to statutorily protected activity, is you say that after Ms. Giese filed the EEO complaint, she was told that she would have to return to work or she would be fired.
That is correct.
But the only evidence, the only reference that I could find to that was in the complaint. I found no evidence of that whatsoever in the record. And I was hoping, can you tell me where is the evidence that she would be fired if she didn't return to work?
I believe Ms. Giese testified to that in her deposition.
I didn't see that. I saw there were several things that happened during that call, but I didn't see any testimony during her deposition that she was told that she would be fired if she didn't return to work.
And you're referring to the...
I forgot the date of the call, but the call with...
Mr. Ellickson?
The human resources.
Yes, I'm sorry, I don't have the exact site.
Okay, but if it exists, it would be in her deposition.
I believe it would,
Okay.
yes. On October 18th, 2018, Lieutenant Michelle Giese had been a firefighter for approximately 20 years. She and her fellow firefighters were called to an active fire at a senior citizen home at 155 West Mertens. She and 5 other male firefighters entered the building and approached the apartment with 2 victims inside, one smoldering. After entering the apartment, Ms. Giese was checking into the kitchen when she felt someone grab her right shoulder from behind. She was forcefully turned around to face defendant Boyce. He proceeded to grab Ms. Giese by the harness that connects her breathing apparatus and lift her off her feet against the wall. He then proceeded to slam her body against the wall 3 times. Eventually, shortly thereafter, they ended up falling into the next hallway where he proceeded to slam her body into the wall another 3 times.
Ms. Walters, your claim based on that conduct is an excessive force claim, but it's a Monell claim. It's not an individual claim.
Correct. It's a Monell claim based
And let's assume you can meet the establishing an underlying Fourth Amendment violation for purposes of my question. As you know, in order to pursue a Monell claim, you need to either identify an express policy, a widespread practice, or the decision by a final decision maker that's the force behind this. And I think you're trying to argue there was a widespread practice, not the policy or final decision maker. Is that correct?
Actually, I would argue that there was a widespread practice, as in a lack of policy. And
well, those are, under the law, those are 2 separate issues.
Oh, I'm sorry. We would be arguing that there's a lack of policy, but we would also argue that there is a policymaker Monell claim, because Chief Schultz did have final policy-making authority under the Kankakee Municipal County ordinances.
But the policy-making, I don't think you made that argument below, has to be the driving force behind the conduct.
Correct.
So what's your evidence that the widespread practice here or the lack of policy was the driving force behind the conduct at work?
Well, essentially, it comes down to the fact that Mr. Boyce had several incidences of violence that went unremarked upon, much less unacted upon.
And do you agree that none of those were instances that occurred at work?
I do not agree with that, Your Honor.
What's the evidence that there's anything in the record that he reacted violently or subjected somebody to excessive force at work?
I believe it was firefighter Cruz who testified that defendant Boyce had thrown a helmet across the room one time in the fire station. Additionally, Ms. Giese and another firefighter, whose name is escaping me at the moment, have testified that they've been pushed and shoved when Mr. Boyce was acting violently at a work outing.
At a work
Outing.
so outside of the workplace.
Yes.
Any other evidence of a widespread practice beyond that?
Not prior to Ms. Giese's.
It has to be prior.
Yes.
Okay, thank you.
Has your client brought tort claims in state court?
Yes.
And are they resolved? Are they pending?
No, the federal judge released jurisdiction.
Okay, and what's the status of the claims though now?
We will be taking them to the state court.
Okay, so there's nothing right now pending in state court.
Correct. After the attack, defendant Boyce testified that this was in response to the fellow firefighters not following his orders that he served over the radio. However, firefighters Johnson, firefighter McCulley, and former Lieutenant Giese all testified that those orders were never given over the radio. After the attack, defendant Boyce then engaged in a meeting outside of the building, but Ms. Giese was precluded from this. On October 20th, 2018, Ms. Giese found out that the union had not been informed of this and informed them herself. 2 days following that, defendant Schultz met informally with Ms. Giese, where he told her that she should amend her schedule to avoid her attacker. On October 26, 2018, Boyce was given the opportunity to meet with the union and Chief Schultz. At that time, Ms. Giese was not allowed at that meeting. She was not given an audience to the union or Chief Schultz in any formal capacity. At this meeting on October 26th, the union leaders indicated that they would waive the normal 10-day requirement that punishment be imposed upon a firefighter and allow Chief Schultz to do an investigation prior to imposing such discipline. Chief Schultz expressed that he did not want this going to the Police and Fire Commission, so he imposed a one-shift suspension at that time. He's testified that he reviewed the personnel file. He saw the previous incidents in Mr. Boyce's file, including the order of protection his ex-girlfriend had to take out on him, including the violent encounter he had with the Bradley Police Department involving a gun, including the driving under the influence charge that he received.
So these points, if they're relevant to the Title VII claim, correct?
Yes.
Okay. And on the Title VII claim, what's the adverse employment action that you can point to?
The adverse employment action in the Title VII claim is Ms. Giese not being given an interview after requesting it with both Mr. Schultz and the union in a formal capacity. Additionally, Ms. Giese made a phone call to HR, I want to say on November 5th, where she found out that HR had not been informed of this. And it is noteworthy that the HR department for the city of Kankakee, the entire city, not just the fire department, consisted of one part-time employee, one female part-time employee. She called that female part-time employee to find out that the HR did not even know about this. 5 to 10 minutes later, she received an angry phone call from Chief Schultz indicating that she should not have called HR. Following that, she was alienated by management, coworkers telling her that they were told not to speak with her. Additionally, when she was brought back on and put on light duty, she found out that Chief Schultz did not tell her immediate supervisors what her light duty assignments were, and she began to be put on duties that she could not perform. And finally, ignoring the advice from her primary therapist that she was not prepared to go back to work, essentially making her work life impossible. I'll reserve the remainder of my time.
Okay, very well. We'll hear from counsel for the city.
Good morning, Your Honors, and may it please the court. David Matthews on behalf of the city and Chief Schultz. The most important issue for this appeal is what is not at issue in this appeal. Nothing before the court today has anything to do with whether Ms. Giese was treated differently on account of being female. Page 28 of her briefs, she abandons those claims. Nothing in this appeal has anything to do with whether she has some sort of legal claim against Mr. Boyce. She has a battery, bad pun intended, of state law torts against Mr. Boyce, and the fact that Mr. Boyce has his own counsel and not counsel for the city should tell you everything you need to know about that. The issue isn't even if Ms. Giese is entitled to some compensation, because as she testified in her deposition at page 25, she was getting $4,400 a month in workers' compensation, and she has a disability pension. The issue is simply, does she have a Fourth Amendment claim for a Monell violation, and does she have a retaliation claim, specifically a retaliation claim under Title VII? The answer to both of those questions is an emphatic no. There are a lot of problems with the Monell claim, starting with the fact that there's no underlying constitutional violation. As this court made very clear in the First Midwest Bank case, sometimes it might be called the Michael Laporta case, Monell is not an independent cause of action. Even what the plaintiff tries to make a big deal about is some sort of alleged conspiracy of silence. It's not an independent cause of action without an underlying constitutional violation. The only possible source here, by the plaintiff's argument, is the Fourth Amendment. And yet, her Fourth Amendment theory presupposes and ignores whether there was a search or a seizure in the first place. Her theory would turn every workplace scuffle between government employees into an excessive force claim simply by virtue of who their employer is. That's not required by the Fourth Amendment's text. It's inconsistent with the case law, and it is just downright illogical. The Torres versus Madrid case is the last word, one of the last words at least, from the Supreme Court about what's a search or a seizure. And what that case specifically says is you need an intent to apprehend, something more than just the physical force itself. When there's no intent to apprehend here, there's no search or seizure. And remember, 14th Amendment gender discrimination cannot be a basis for a Monell claim because she abandoned those claims. In addition, as Judge St. Eve pointed out, there's no widespread pattern or practice. There's one incident, and when it comes to these prior incidents of the workplace, Your Honors, I would I would direct you to the short appendix, page 54, where the plaintiff admits as an undisputed fact that there were no prior incidents of workplace violence at the fire department before Mr. Boyce did what he did.
Mr. Matthews, let me go back to your Fourth Amendment point. I think the issue with the Fourth Amendment claim is that I totally get the alleged state law tort claims. The difficulty I have with the Fourth Amendment claim is when Lieutenant Boyce engages in that activity, that conduct. Very troubling set of allegations. It's difficult to see him acting as a state actor, right? The Fourth Amendment doesn't regulate private conduct, as you know, that way, right? So he's not acting, I know he's a firefighter, but he's not acting in a firefighting or law enforcement capacity when he engages in conduct that's so ultra-virus like that.
I think that's a very good argument, and I would remind Your Honor and your fellow panelists that I'm sorry, Judge, I didn't mean to interrupt you.
It just seems to me that it's not, I think it's a very difficult claim to say she's not seized, okay, in any kind of fair understanding of the term. There's just no Fourth Amendment activity here because it's not state action that he's engaged in.
I think you could certainly
Maybe
argue
it may very well be unlawful conduct.
well, if everything that Ms. Giese says is true, it may well be a battery under Illinois law. Again, Mr. Boyce has his own lawyer, and I can't speak to that. You could certainly say that it's not state action and that Mr. Boyce is acting out of just a private ill temper. And I would remind Your Honors, you can affirm based on any reason supported by the record, while the plaintiff has to preserve her arguments.
And then you still got then you got to take it into the Monell world.
Which
right?
is where I was going next, and as Judge St. Eve pointed out, the plaintiff did not, in fact, make a final policymaker argument. She waived that argument after I pointed out that there is an Illinois statute saying the Board of Police and Fire Commissioners is the final policymaker. She had no response, and that's a waiver. One last thing with respect to the Fourth Amendment argument, and you could go either way. Is it state action? I mean, is he trying to further the firefighting? Maybe. But even though Ms. Giese was grabbed, I would argue that under Torres versus Madrid, she's not seized within the meaning of the Fourth Amendment. There's no attempt to apprehend her beyond the physical contact itself. It's kind of similar to the Blake versus Regan District Court case that I cited. But there's no pattern or practice. There's no final policymaker. And there's no official policy because Mr. Boyce's actions were against policy. He got disciplined. Now, as the deposition testimony, some of his fellow firefighters thought he shouldn't have been disciplined at all. Some thought the discipline was way too light. Maybe there was someone who actually, like the Goldilocks, thought it was just right. I don't know. But
Is there any remedy for that?
There's no federal constitutional remedy. There's no.
Is there any remedy for Ms. Giese to challenge the discipline imposed?
Not that I'm aware of. There's always possible that there's something under the union contract, but any rights that Ms. Giese would have would be under the union contract because she's a union employee. I don't think so, but I can't be certain. What I can be certain of is that nothing in the federal constitution or Title VII or a Title VII retaliation claim gives an employee a legal interest in the discipline given to another employee. As to that retaliation claim, most of what the plaintiff is arguing as retaliatory predated her protected activity. Her protected activity was filing an EEOC claim. She argues in her opening brief that it was filing a workers' comp claim, and she says that this court has decided that. In my response, I pointed out that the cases she cited are district court cases. They don't decide that issue at all, and in fact, a number of courts have gone the other way, and the response to that from the plaintiff is just simply silence. So her only protected activity is the EEOC brief, filing.
We've never addressed the workers' compensation claim one way or the other, correct?
That, as far as I can tell, Your Honor, that is correct. Lower courts have said that workers' compensation, federal district courts have said that it is not a Title VII protected activity. It might be under the FMLA, it might be under state statute, but not under Title VII. And there is very good logical, I would say textual reasons why it shouldn't be, because the retaliation statute is specific to Title VII. The only thing that happened after her EEOC claim is she was asked to go back to work to do what 2 PhD psychologists, including one selected by her therapist, said she could do. Now, the plaintiff said at the very end of her argument that she was required to do tasks when she came back that she couldn't do. But in the plaintiff's, Ms. Giese's deposition, and I'll direct you to pages 185 to 188, which I cite in my briefs, she actually admitted the opposite. She admitted she was never required to do something after telling her supervisor that she couldn't do it. The only argument the plaintiff could make to try to push that retaliation timeline forward and salvage her claim would be to say that talking to HR was protected activity. And she cites some cases about that, and certainly talking to HR can be protected activity, but only if someone says specifically that they are being discriminated against or mistreated on account of their gender or some other Title VII capacity. Generally going to HR and saying that it's unfair, I don't like the way this is going, doesn't trigger Title VII's retaliation.
Well, didn't she say more than that? Didn't she say, look, why am I the one that has to change my schedule but not him?
She may very well have said that, but that's not sufficient to say that she's being treated unfairly on account of being female. That doesn't put an HR person on notice of a Title VII retaliation claim. It's just a general workplace grievance.
Okay, thank you, Mr. Matthews. Ms. Walters?
I'd like to initially address. Oh,
Go ahead, you got a minute. Go ahead.
thank you. I'd like to initially address counsel's misstatement about the Fourth Amendment claim here. In his brief, he relies upon cases for a show of authority of intent to apprehend, none of which are analogous to this case. The Torres versus Madrid case did not indicate one needs to apprehend. The issue in that case was whether an attempt to apprehend but failure to apprehend can be a seizure under the Fourth Amendment. Additionally, the McCoy v. Harrison case, which Mr. Matthews relies on heavily, additionally is not analogous to this case. In both of those cases, in the McCoy case, the victim's freedom was not restrained. And that is why the court decided it was not a Fourth Amendment seizure. In the other three cases, one out of DC, the other two out of district courts, one being Illinois, one being Oregon, are also distinguishable. Each one of these cases, the victim was not restrained. One was a genital grabbing. Actually, two were a genital grabbing. And the other one was a bystander on a subway. None of them are analogous. In this particular case, not only was Ms. Giese being held against a wall, but she was lifted off the ground. She was absolutely restrained under the Fourth Amendment.
Okay, very well. Thank you.
Thank you.
Thanks, Ms. Walters. Mr. Matthews, thanks to you as well. We'll take the appeal under advisement. We'll move to our final argument of the morning. It's appeal number 222831, Jennifer Homan versus the Commissioner of Social Security. Mr. Duncan, nice to see you.
Good morning, Your Honors. May it please the court, Dana Duncan on behalf of Jennifer Homan. The claimant was 51 years of age at the time of the alleged onset. The ALJ found she was limited to light exertional work. At age 51, if limited to sedentary work, she would have met the grid rule. So that's one of the reasons why the second issue in this case was brought forward, which is her subjective statements could very well have led to a favorable decision. The first issue, though, is the one I'll address. We're back before the court again on vocational testimony. And I think that what I'm getting, or what I'm seeing in some of the district courts, is that they're upholding these if there's any method discussed. And while the agency wants to say that my standard or what I'm asking for is excessive, that I'm asking for precision, I'm not. The testimony from the vocational expert has to be at least sufficient for a reviewer, whether it be counsel for the claimant, whether it be the ALJ, whether it be a district court, the appeals counsel, whoever, to trace the path of reasoning employed by the vocational expert. Okay, and in this particular case, I mean, he talks about, he provides statements about weighing evidence and putting a weighted estimate, but there's no real explanation for any of it. The HALEX, which the judge is supposed to follow, I think was adopted pretty much, or follows along the path of BSTIC, which says that when a response is provided, it has to be understandable to the average person.
Mr. Duncan, how do we distinguish this case from Fetting? Because it seems like the methodologies used by the vocational expert in both cases were pretty similar.
Okay, the problem comes in, again, that Fedek was a little more detailed and a little more precise as to how he went about going
More
through it.
detailed than this? This one seemed more detailed to me than Fetting.
Except that he provided a lot of testimony, but the testimony doesn't say a whole lot. That's the problem. Let me just put it this way, all right? It's easy enough to do. If the vocational expert would have simply provided the following. We have the one SOC code that had 14 DOT codes in it, okay? If he says that I don't use a computer program like Job Browser Pro, which he did, and I don't use the EOQ, the Occupation Employment Quarterly, I do my own calculations. And what I did was I looked at the 14 jobs, and based on my knowledge and experience, 8 of those jobs do not exist in significant numbers. So that leaves 6 of those jobs left. And I've done a market study on 2 of those jobs, and I know that a predominant number of those jobs fall into those 2 categories, into those 2 occupations. And so therefore, I came up with an estimate based on that to provide it. That's clear. If that was the testimony, I would not be here today. But it's not. What we have is just a lot of vague statements that do not provide a whole lot.
Mr. Duncan, I see this case, maybe you'll disagree with this, but Mr. Forbes argued a case called Brace.
Yes.
Do you know Brace?
Yes, I'm very familiar.
Okay. So I view Brace and Fetting as kind of bookends here.
Okay.
Okay. And I think this, to me, could it be clearer? Of course it could be. But it seems much closer to Fetting than it does to Brace. And in Brace, I was on the Brace panel.
Yes.
Got Brace right here. Okay. What made very little sense to us in Brace is there was this repetition of I weighted this, I weighted that. Hold on, what are you talking about? We don't have any idea what that means, okay? But here, and this is where you're probably going to disagree, and it's going to benefit to hear you do it, okay? Here, Mr. Hyman, right? He's the VE, Tom Hyman?
Yes.
Okay. Mr. Hyman here uses the word weighting in a quite imprecise way. I'll give you that. Okay? But I can follow, I think, what he's saying. And what he's saying is that when you look at the 14 jobs, I think this particular applicant can perform the role of a mail clerk. Equal distribution gives you 85,000. I don't buy 85,000. Okay? And I think the mail clerk is more weighted, forgive the term, toward 40. Why? Because some of these have been absorbed by modern technology, some of these positions, etc. Okay. Could you be more articulate with that? Of course you can. But you get the gist of it. In other words, I read this. I get how he arrived at it. I get what he drew upon. Is he fully showing his work? No, that's a fair observation. But is that the standard to which we should hold him?
The standard which we should be able to hold him to is so that we have the ability to point out when that logic is flawed. Okay? If we're in a situation where, even in this particular case, I have no idea exactly how he weighed it. He was given multiple opportunities to do it. And I still have no clue exactly how he came up to that 40,000. If he just provided just brief statements as to how he came up with it, then I have an opportunity. I mean, this was not my case, but I would have had an opportunity to ask him questions and see if his statements were...
Why isn't his testimony that he did it based on his 25 years of experience and job placement sufficient to explain why?
Because
the test is it understandable to the layperson?
Okay, because 25 years of job placement does not necessarily mean that he has the ability to come up with numbers that range across the entire United States. That's the flaw in the logic, which is vocational experts are trained to place individuals and are trained to deal with their limitations. They're not statisticians, but they're asked to become
But he
statisticians.
testified here that he had conducted, I think, over 2,000 surveys
Correct.
of labor markets, covering virtually every metropolitan area. He had taken notice of some of the proprietary software. He's giving the base more than just, oh, I've been doing this for 25 years. He's putting meat on the bones. Why isn't that sufficient?
Okay. As I indicated in the brief, page 65 of the record, Mr. Heinemann's testimony in regards to his job or his labor market studies, I had made no heads or tail out of what he was saying. And that's the problem that comes up, is that if I can't be able to cross-examine the attorney, or as the attorney, the vocational expert, in such a way that I am satisfied that their testimony is based upon something other than an educated guess, then it throws all of the step 5 consideration out the window. I mean, these cases rest most of the time at step 5 on the vocational testimony. And if we continually have vocational testimony that's unclear and that prohibits proper and full cross-examination, at some point in time, it's pointless.
Mr. Duncan, one thing I have no doubt about is, had you cross-examined Mr. Hyman, I think you would have said, I have no idea what you just said.
Yes, I would have. I've done
Right.
it multiple times.
Right. You're using the term weighting. You're talking about studies. You need to get a lot more specific, because at that level of generality, I have not a clue what you're saying.
Correct.
Okay. That's not the exam that was
I know.
conducted here. We're left with the record we're left with.
Well, the only thing I can indicate is the judge ultimately decided it based upon the fact that he said that he's done these market studies. And that's even less clear than what is even there. The attorney of record did ask on several occasions, what do you mean by weighing it? He was given multiple opportunities. He never clarified it.
Okay.
So-
You want to save some time, or you want to address fibromyalgia now, or you want to save it?
The only thing I'll just use it and go.
No, we're
Okay.
going to give you some time. Go ahead.
Okay. The only thing I wanted to indicate on the fibromyalgia is the standard of review that's being put in some of the decisions now is the record fails to fully substantiate the allegations of disabling symptoms. That seems to imply that the claimant has to be found totally credible, consistent with the record, in order to have a credibility finding. And in this particular case, her testimony was that she has difficulty with standing for lengths of time, which would support a sedentary restriction. She has other problems associated with it. There's case law in the district courts that have indicated that this seems to imply a standard of review that's beyond what the statute allows. And 20 CFR 404.1529C2 indicates we will not reject your statements about the intensity or persistence of your pain or other symptoms about the effect your symptoms have on ability to work solely because the available objective medical evidence does not substantiate your statements. And that is ultimately what ends up happening in this particular case. I understand that the judge has wider discretion in these cases, but the standard of review should be clearer and should indicate why, specifically, what was contrary to her statements. I mean, this is a fibromyalgia case. It's not like there's an MRI that we can look at.
So I want to hold on. When you were saying the case law is getting a little sloppy in your view, our case law, district court case law, what case?
The district courts have been looking at this and raising this as being somewhat suspect. I don't think this court has
The proper
had a
framing
chance.
of this is 12-2P, right?
Yes,
Okay.
and that ruling outlines all of the different medical conditions, findings, and such that you're supposed to take into account. And I think the brief lays out that you consider these for your step 2 analysis. Is it a severe impairment? Then they go on to step 3 and decide whether or not there's a listing that's equaled, because there is no fibromyalgia listing. And then from there, the findings that you make, whether it be IBS, whether it be depression, etc., those are then converted into the residual functional capacity. And one of the things that you have to take into account, and it specifically indicates in there, that subjective statements have to be taken into account and weighed when you're doing this. If we're putting a standard of review that's in excess of what the statute says, then I question whether that was ever really done.
Okay, very well. Appreciate it. Ms. Hugo?
May it please the court, Megan Hugo on behalf of the commissioner. I'll start with vocational expert issues since that's how Mr. Duncan started. And in this case, Mr. Hyman's testimony is substantial evidence in support of the ALJ's decision that approximately 130,000 national jobs existed that Ms. Holman could perform. Now, counsel is focusing on what's missing from the vocational expert's testimony, but that approach ignores the substantial evidence standard. Properly focusing on what the vocational expert in this case did say, it is clear that his testimony easily crosses the more than a mere scintilla threshold for substantial evidence. And indeed, the court recently reaffirmed in the Fetting and SOC cases vocational expert testimony that is very similar to the testimony that Mr. Hyman offered here. In this case, Mr. Hyman identified the source of his job numbers, which was national jobs data from the Bureau of Labor Statistics, and then he explained how he analyzed that data. He said that he makes a weighted estimate based on his professional experience, which included 25 years in job placement, conducting 2,000 labor market surveys that collected data about the existence of current and future jobs and labor market fluctuations. His survey spanned every major metropolitan statistical area in the United States. He also had discussions with thousands of employers and his own colleagues about those same topics, the prevalence of jobs and the economy and labor market variations.
You think it's clear enough from the context that when he was talking about the weighting, he's talking about the relative weighting of how the 85,000 jobs across the 14 codes apply to the mail clerk position in light of his experience and looking at the surveys. And so that's what he means by weighting.
Correct.
It's a relative determination of the one position across the 14.
Correct. And I think, that becomes clear when he does go into how he did it with the mail clerk job. He said based on his knowledge of the job market and, in fact, his on-the-ground experience in working in the printing industry, which he said actually involved this type of work, he knows that some of these 14 occupations have been subsumed within other occupations, and some of them have even been eliminated by technology altogether. And, I'm not a vocational expert. That's why we have vocational experts. But just looking at the copy of the OEQ that counsel attached to his reply brief, it seems on its face reasonable that some of these positions either no longer exist or have been combined. And so,
Is it necessary to have testimony about the reliability of the methodology in terms of being accepted in the community?
I don't think this court has ever said that the vocational expert has to affirmatively say my methodology is reliable and accepted. I think there's nothing in his testimony here that indicates that he finds it unreliable. In fact, he gave very specific foundation for his numbers and, including his extensive experience in the industry and in placing people in these exact jobs in the past. Again, the court recently reaffirmed this very approach in Fetting and SOC and endorsed this approach in Chavez when it said that vocational experts could support their estimates with knowledge of the job market that they have obtained through job placement. So I don't think...
Where's the line? Would it be enough to just say, I've been doing this for 25 years?
It has to be case specific. I mean, if he comes in here and says, I've been doing this for 25 years and, counsel asks no further questions that cast doubt on that, I think that's, a Fetting and a Coyer forfeiture case. If then the attorney comes in and says, what's your experience? And the experience has nothing relevant to do with the job numbers, then I think the ALJ, it's incumbent to ask more. So it is a case-by-case inquiry, but the court has said that as long as there's, nothing that casts doubt on the reliability of the testimony, the ALJ has no duty to inquire further. And so in this case, given all the indicia of reliability in his testimony, where he gave the source of his numbers, he outlined his process, he gave a specific example, he said he had experience in the industry, and he explained why he thought that some of these jobs shouldn't be included in the weighting. That's a sufficiently reasonable example under this court's precedent. And again, this testimony is very similar to what the court found reasonable in Fetting and Sock recently. The vocational expert, who was the same individual, Mr. Gusloff, in both cases, broadly testified that he looked at the composition of the larger SOC group and then estimated the number of jobs available to claimant based on the knowledge of the labor market and gained from 30 years of job placement. Similar to those cases, I think the court should find here that Mr. Hyman gave enough detail about his sources and his process, and that he could rely on his significant professional experience to produce a reliable estimate for the ALJ to accept as reasonable. And turning to fibromyalgia, if I understand counsel's argument, that I think he's saying that the ALJ used the wrong standard in evaluating her complaints because the decision has that failed to fully substantiate language. And this court has rejected that reflects a misunderstanding or a misapplication of the proper standard. In the Gedatus versus Saul case, the court basically said...
Say what case again?
Gedatus, Gedatus versus Saul, rejected this very argument that by using any sort of boilerplate, it reflects a misunderstanding of the standard of review, and just said basically, that's just a polite way of saying that the evidence didn't fully substantiate her claims. And again, the court has held many decisions where it says that the use of boilerplate is not reversible as long as the ALJ gives sufficient reasons for the subjective symptom analysis. And that's exactly what the ALJ did here. I think it is important to note, though, that the ALJ didn't fully reject her complaints and, in fact, gave credence to some of her subjective allegations. The ALJ limited her to light work, which is consistent with what the state agency expert said was appropriate, but explained that she included more restrictive postural limitations to account in part for her testimony. The ALJ also limited Ms. Holman to work involving occasional social contact and work that could be performed independently. Again, that's more restrictive than what the state agency psychologist suggested, and the ALJ explained that was due in part to give deference to her testimony. And significantly...
the social condition is important to me here, because I actually think that's what fully aligns with her testimony. So when I read her testimony, she's very much talking about difficulty that she experiences working with others, working in teams, working in group settings, and how she experiences a lot of anxiety, and with the anxiety comes the pain and all that. That's where I think Mr. Duncan has a hard time on that, on the RFC, because the ALJ picked up on that and then included that social limitation.
Absolutely, and again, that's above and beyond what the state agency experts indicated was necessary. And you're absolutely right, Ms. Holman testified that the stress of working around people was her biggest challenge in keeping a job, and that such stress tended to trigger her fibromyalgia symptoms. So the ALJ, took into account her testimony, and to the extent that her allegations were supported by the record, accounted for that and tailored a residual functional capacity that accounted for her limitations as they were substantiated by the record. Where the ALJ departed from Ms. Holman's allegations, he gave a sufficient explanation that did not rely solely on the objective medical evidence. First, the ALJ considered that Ms. Holman had undergone a generally conservative course of treatment and that her medications had controlled or reduced her symptoms. And that is borne out by the record. Ms. Holman herself told her psychiatrist that her fibromyalgia pain was greatly diminished when she restarted Cymbalta. The ALJ also considered that Ms. Holman was first diagnosed with fibromyalgia in 2013, but continued to work full-time without report of physical limitations or difficulties until April 2018. He considered that her daily activities were inconsistent with her subjective complaints, that she made inconsistent statements about her physical limitations. For instance, the ALJ noted that Ms. Holman told the psychological examiner that her physical health over the years was in the normal range. And the ALJ appropriately did consider the objective medical evidence. Even in cases of fibromyalgia, the Social Security Act, the rulings, and the regulations direct ALJs to consider objective medical evidence. And the ALJ appropriately did that here, noting records where she was in no acute distress, she had normal range of motion, normal muscle tone, full strength, and intact sensation. And this court in the Gebauer versus Saul case noted that the agency's guidance on how to evaluate pain, which is fibromyalgia's chief symptom, directs ALJs to consider such objective findings like the ALJ considered here. So in short, the ALJ did accept some of Ms. Homewood's complaints and accounted for them in the residual functional capacity and provided a sufficient explanation of why he did not accept her account of disabling symptoms. And if the court has no further questions, I'd respectfully request that you affirm the district court.
Thank you, Ms. Hugo. Mr. Duncan?
I'm going to take one last shot at trying to convince you of the difficulty of this situation. Okay, we're sitting in a hearing, and we have no idea what the vocational expert is going to say. We have no idea what jobs they're going to provide. We have very limited idea of what the administrative law judge is going to provide for a hypothetical question. Now, the last two hearings I've had myself, because I feel that it's almost that the agency is expecting that we prove the vocational expert testimony is flawed, so that shifting the burden of proof. I filed both times 5-page brief with over 100 pages of additional materials from various publications and filed that with the ALJ. Okay, that's the steps that I have to go through in order to establish based on that standard. And these are supposed to be informal hearings and non-attorneys.
Were you successful?
One of the cases the judge just scheduled for new vocational testimony because he threw up his hands and said, "You're probably right, and I'm not going to go forward." I haven't gotten a decision on the other one yet. But that's the problem that we have. And I would love it if, everybody was able to do that, but we have a lot of unrepped people. We have a lot of people who have non-attorney representatives and a lot of people who just dabble in this. And I have to say that that there has to be or should be some standard that when the issue is raised and you've made clear there has to be an objection, has to be at least something that would trigger the knowledge of the ALJ that there's an issue here, so that we can get some clarity. Only 5% of denials out of the 1.2 million, I think, annually are appealed to federal court.
Well, one great source of clarity would be if the agency would come forward with the system, a new system for this, and we'd move away from the equal distribution method. That's not for Ms. Hugo to solve, but I think that discussion started in 2002, quite a while ago.
The ORS is available through Job Browser Pro, and I've had vocational experts testify that they can't use it because it's not reliable or that they're not allowed to use it, which is false, which the regulation clearly indicates that they have the ability to use any governmental publication that's deemed reliable, and the ORS should be, as is the ONET. And but that's a problem that hopefully will be resolved. But I have about 10 years left, and I've been waiting since 1998 for this to be fixed. So we'll see.
Okay, Mr. Duncan,
Thank you.
thank you. Ms. Hugo, thanks to you. That concludes this morning's arguments, and the court will be in recess.